Did you know that your job is protected while you're on medical leave? And the duration of that job protection, in this case, and other related rights, depends entirely on your jurisdiction. Why does this matter? Here's the law. You've been diagnosed with a serious illness. You can't work. You're terrified about your job, your income, your future. You're not alone. At any given time, 8 to 12% of the Canadian workforce is off work due to injury or illness. Here's the question that keeps most people up at night. Will my job still be there when I come back? Will I lose everything? Today, we are going to break down exactly what your rights are during medical leave, how long your job is protected, what happens if your leave is extended, and most importantly, how to protect yourself legally and financially while you focus on your recovery. Let's get into it. Let's start with the fundamentals. You have a legal right to medical leave. Under the Federal Canada Labor Code, every employee is entitled to up to 27 weeks of unpaid job-protected medical leave for personal illness or injury. The law is absolutely clear. An employer is prohibited from dismissing, suspending, laying off, demoting, or disciplining an employee because they intend to take or have taken a medical leave. Provincial protections vary, but are generally similar. So, for example, in Ontario, as of June 19, 2025, employees with at least 13 consecutive weeks of service are entitled to up to 27 weeks of unpaid job-protected long-term illness leave within a 52-week period. In British Columbia, amendments to the Employment Standards Act allow up to 27 weeks of unpaid leave within a 52-week period for employees with a serious personal illness or injury. In Alberta, eligible employees can take up to 27 weeks of unpaid job-protected leave per calendar year due to their own long-term illness, injury, or quarantine. Saskatchewan and other provinces have similar provisions. So the takeaway here is across Canada, you have a legal right to take time off for medical reasons without losing your job for a specific period of time. But here is where it gets complicated. Once your protected leave ends, your job protections also end. And that's where many employees find themselves in a precarious position. So, what happens when your leave is extended? Now, let's start with the situation where that causes the most anxiety. What happens if your medical leave extends beyond the protected period? The short answer is your employer can terminate you. But there are important legal safeguards. First, the duty to accommodate. Under Canadian human rights legislation, employers have a legal duty to accommodate an employee's medical restrictions to the point of undue hardship. This duty applies if your medical condition rises to the level of a disability under human rights law, which would include physical illness, mental health conditions, depression, anxiety, and PTSD. The Supreme Court of Canada has stated that the goal of accommodation is to ensure that an employee who is able to work can do so. This means, or this does not mean, your employer must accommodate you indefinitely, okay? But it does mean they must explore all reasonable options before concluding that accommodation would cause undue hardship. Now, let's also get a better understanding of what undue hardship means. The test is whether accommodating the employee would cause the employer significant difficulty or expense. It is a high threshold, not merely inconvenience. Second, the risk of constructive dismissal. If your employer replaces you during a protected leave without proper notice or communication, that can constitute constructive dismissal. The case of Nunes, Schuler, and Osoyo's Indian band is a powerful example. Melinda Nunes Schuler worked for the Osoyo's Indian band for nearly 20 years. She went on medical leave in July 2017. When she returned, she was subjected to demeaning treatment, like she was refused a proper workstation, demoted without disclosure. Her position was permanently filled by another employee. The BC Supreme Court found she had been constructively dismissed and awarded her 24 months notice compensation plus $50,000 in aggravated damages for the employer's bad faith conduct. The court found the employer's conduct was misleading, unfair, and done in bad faith. The bottom line, employers cannot simply replace you while you're on medical leave and hope you would go away. That is a recipe for a constructive dismissal claim. Now, let's get practical. Here is exactly what you need to do to protect yourself. Step 1, know your income sources. While you're on medical leave, your income may come from several sources, like short-term disability, STD, typically covers 60 to 70% of your salary for a limited period of time, which often is up to 17 weeks. Long-term disability, LTD benefits, that usually kicks in after the short-term disability ends. And that's often after the 17 weeks. Employment insurance, EI, sickness benefits, up to 26 weeks of benefits if you are away from work for medical reasons. Note, apply for your EI sickness benefit immediately. That's a 1-week waiting period. Step 2, get proper medical documentation. To access job protected leave and disability benefits, you will need proper medical documentation. A vague doctor's note saying you can't work is usually not enough. You should provide reasonable medical details, such as a functional abilities form, FAF, if your employer asks for it. In Ontario, employers can no longer require a doctor's note for sick leave of 3 days or less. They may request alternative evidence like a signed self-attestation, for example. But for extended leave, medical documentation is absolutely essential. We'll get to that a bit more later. Now, step 3, communicate with your employer. Accommodation is a two-way street. You must inform your employer of your medical restrictions and provide relevant prognosis information. If you're not required to disclose, if you don't want to disclose, or there's no any requirement to disclose a specific diagnosis, just enough information on a need-to-know basis to allow your employer to access and implement necessary accommodations on your behalf. Step 4, keep a paper trail. Document everything. Emails and letters you exchange with your employer, medical notes and certificates, records of phone calls and conversations, your employer's responses or lack thereof. All of those material information will become necessary in this case. In Nunes-Schuler, the employer's failure to respond to the rehab's consultants' calls and emails for 7 months was a key factor in the court's finding of bad faith. Now, step 5, know when to seek legal advice. This is very important. If your employer pressures you to resign, for example, stops communicating with you, replaces your position without notice, demotes you upon your return, refuses to accommodate your medical restrictions, you should seek legal advice immediately. You may have a claim for constructive dismissal or a human rights complaint. Now, let's talk about what to do if your employer treats you unfairly while you're on medical leave. First, recognize the warning signs. Employers who are acting in bad faith may, for example, pressure you to resign, refuse to communicate with you or your rehab consultant, demote you upon your return, or fill your position without telling you. Make your return to work unnecessarily difficult. Those are all the signs you should be watching out for. Second, understand your legal protections. Under the Canada Labor Code, you are protected from reprisals for taking medical leave. An employer cannot dismiss, suspend, lay off, or demote you, or even impose a financial or other penalty on you because you took a medical leave. Take your leave into account, for example, in any decision to promote you or train you. It's a condition or a situation where they're not taking you, or at least acting in good faith, as in the previous case that I referred to from the BC Supreme Court. Third, consider your options. If your employer has fundamentally changed the terms of your employment or made your work environment unbearable, you may have a claim for constructive dismissal. Now, a quick reminder, constructive dismissal occurs when the employer makes a single unilateral breach of an essential term of the contract. The employer engages in a course of conduct that shows they no longer intend to be bound by the employment contract. In Nunes Schuler, the employee was constructively dismissed because her employer refused to provide a proper workstation. Further, the employer demoted her without disclosure, then replaced her position during her medical leave. Fourth, do not resign impulsively. If you resign, you must do so clearly and unequivocally in response to the employer's fundamental breach. Resigning for personal reasons or another opportunity has come up type of reason can undermine your claim. Fifth, file a complaint if necessary. If you believe your employer has discriminated against you based on disability, you can file a complaint with the Canadian Human Rights Commission for federally regulated employees. Your provincial Human Rights Commission is also available. You can also file a complaint with the Canada Industrial Relations Board if you believe your employer has violated the Canada Labor Code. The bottom line is you have rights. Use them. Now, let's be honest about something that rarely gets discussed in legal guides: the fear. You're on a medical leave, you're already dealing with illness, pain, and uncertainty. On top of that, you're terrified about your job, your income, and your family's future. Here's the truth. That fear is valid, but it shouldn't paralyze you. Know your right. The law is on your side, at least for the protected period of your medical leave. Know your income sources. You have options. For example, EI sickness benefits, short-term disability benefits, long-term disability benefits. Know your employer's obligations. They have a duty to accommodate you to the point of undue hardship. Know your next steps. If your employer crosses the line, you have legal recourse. And know this, you're not alone. At any given time, 8 to 12% of the Canadian workforce is off work due to injury or illness. Thousands of Canadians have navigated this path before you, and thousands more will navigate it after you. The system by no means is perfect, but it does provide protections. Your job is to know those protections and to use them. Now, here's the conclusion. And here's the law, and here's your move. If you are on medical leave, know your province rules. Check employment standards legislation. Get proper medical documentation. Communicate with your employer. Apply for EI sickness benefits and check your group benefits. Document everything. Above all, seek legal advice if your employer acts in bad faith. You have rights. You have options. And you are not alone. This is iChatLaw, where the law gets real. If you found this helpful, like, subscribe, and turn on the post notifications. We post every weekday, Monday to Friday, daily legal updates, daily empowerment